Okay, good morning, everyone. Welcome to the Michigan Supreme Court first Zoom oral argument. We will hear two cases this morning. We're going to do this again next week with two more cases. And we hope you'll all bear with us as we figure out how to make this virtual platform work in this unique time. The way we're going to proceed is after I call the case, the appellants will argue for 5 minutes without interruption, and then I will turn to each justice for any questions they have, followed by the appellee's 5-minute argument, also uninterrupted, and the same process. The appellants in this case, I think there are two lawyers splitting time, but I'll let you all tell us about that and introduce yourselves. And I think we'll just go ahead and call the first case. It's also, I should also say that if you want to reserve time, please try and manage it yourselves. We have the clock up here on Zoom, but we're all going to be doing our best. So calling this first case, Gaydos versus Bender. Ms. Klaus and Mr. Brennan, I'll let you decide who's arguing first and how you're going to split your time. Mr. Brennan, I'm sorry. Yeah.
I believe Ms. Klaus is going to go first, but she appears to be muted.
Yeah, we have to unmute Ms. Klaus.
That's bad. There we go. That's correct. We decided that I would go first and that we'd split our time.
That sounds great. You may proceed.
Thank you. I'm Kate Klaus, and I'm here on behalf of the appellants Ken Mogul and his law firm. I want to thank the court for allowing us to argue our application during the emergency shutdown. This court has shown that it can carry out its important work safely, and that in the state of Michigan, justice never rests. The question the court asked us to answer is whether the holding in Maiden versus Roswood should be extended to suits brought against retained expert witnesses. The pertinent part of that holding for our case is twofold. One, expert witnesses are immune from giving incompetent opinions, and two, that immunity extends to out-of-court work that is a necessary predicate to the opinion. In order to answer the court's question, we have to understand the principles that gave rise to the immunity and determine whether those principles would be abrogated or reinforced by protecting retained experts from suits brought by disgruntled litigants. This issue can't be decided by balancing the rights of injured persons and the rights of persons who are alleged to have caused the injury. Our question addresses the scales themselves. Will affording retained experts the same immunity afforded every other witness ensure that the balance of our scales of justice remain true? In Briscoe, the U.S. Supreme Court studied the centuries-old precedent that allowed immunity to all witnesses and distilled the reason for that immunity into a simple phrase: the paths to the attainment of truth must be as free and unobstructed as possible. And this principle isn't a trope that attorneys or judges trot out to justify a difficult position or decision. The principle is a fundamental and elemental part of our judicial system designed to ensure its integrity. And the Briscoe court was asked to determine witness immunity and whether it was extended to a police officer who gave perjured testimony. And the court found that because the police officer's function in the judicial proceeding was the same as any other witness, he must be afforded the same immunity. In Michigan, the function of an expert witness is to assist the trier of fact to understand the evidence or to determine a fact and issue. And there can be no doubt that this function will be impaired if the expert is subject to suit by the attorney who retained him. First, fact finders must be able to rely on candid, objective, and undistorted evidence. An expert will not provide this type of evidence if she believes that she will be sued if the case is lost. She will tailor her testimony to support the party who retained her without regard to the truth of the testimony or the integrity of her opinion. Courts from other states have suggested that this candor and objectivity are not relevant when the expert witness is retained because experts are paid to give favorable testimony. But this is not the law in Michigan. MRE 702 requires the trial court to act as a gatekeeper against hired guns. 702 dictates that expert witnesses owe the court both a duty of candor and a duty of competence. Retained experts are people, just like every other witness. They will lie or shade the truth if they are afraid of being sued, leading to an outcome that is contrary to the reason expert witnesses are necessary in the first place, to assist the trier of fact in deciding the issues presented to it. A second way in which the allowing suits against retained experts will obstruct the path to the attainment of truth is that it will stop real experts from participating in litigation out of fear of being sued. This will drive up the costs of litigation because experts will need to be induced financially to participate or procure professional liability insurance. And think about a case that might be worth $100,000. It could be life-changing to the plaintiff, but the cost of an expert who has procured liability insurance would make bringing the case cost prohibitive. The attorneys and expert fees would erode the award. I'd like to turn the argument now to Mr. Brennan, who has an explanation of alternative remedies where applying this immunity will not deprive plaintiffs of a remedy for any injuries.
Mr. Brennan?
Thank you. May it please the court. I'd like to actually address in terms of the remedy and what the Court of Appeals did to focus on the misapprehension of the Court of Appeals with regard to the policy considerations that form the basis of their opinion. The policy considerations in Maiden were clearly focused on the freedom that witnesses must have to give damaging testimony without fear of reprisal. That's what the Court of Appeals said in its opinion. The Court of Appeals emphasized the word damaging and construed that to mean unfavorable. But in Maiden, this court never used the words damaging or unfavorable when it recognized the policy underlying the immunity doctrine. Instead, this court quoted from its own opinion in Dowd versus DeLoe, which stated that the immunity is grounded in the need of the judicial system for testimony from witnesses who, taking their oaths, are free of concern that they themselves will be targeted by the loser for further litigation. Now, the court's use of the term loser rather than adverse party is telling and supports the policy that regardless of who may be disappointed by the testimony, the policy concern is to protect the witness's ability to testify without fear of reprisal by anyone save for perjury. So the policy concern is for the adversary system of justice, which recognizes the role of the trial attorney's duty to the litigant to present the best case for his or her client. It also recognizes that in the context of litigation, the expert is hired not to perform the work of a doctor, an architect, an attorney, an engineer, or, as in my client's case, a broker. They are retained to provide their personal opinions as witnesses based on their expertise. In my case, my client was asked to give an opinion about the duty owed to a client, and in the course of his business, he's not typically called upon to give experts on what the ethical obligations are in his business. He abides by those, but in terms of giving an opinion and how he formulated his opinion, that's not why he wasn't hired as a broker. He's hired as a witness, as a professional witness, or excuse me, as a witness that is giving his testimony based on his professional experience. And that role is shaped by the trial attorney, who alone controls the levers that are pulled in the context of litigation. As an attorney, I search for the expert, I review the qualifications, I choose the expert. It's my duty to set the parameters of the expert's scope of inquiry. I ask the questions that I take on depositions that are relied upon by the expert. I direct my expert's focus on what I deem relevant for my case. I review the draft expert reports and suggest further areas of development. I'm responsible for demonstrating to the court that the testimony is admissible and that it's not junk science under this court's Gilbert versus Daimler Chrysler Corp standard. And I examine the witness at the trial and I argue to the jury what the testimony should prove. So it's my responsibility as the attorney that the testimony is developed properly, and I'm responsible for vetting the witness. If a second opinion is needed to test the merits of the opinion, then I'm the one who should be seeking it out. The Court of Appeals decision undermines that responsibility by allowing the trial attorney basically to point the finger at the expert. It also doesn't consider how the scope of the expert's work is manipulated and shaped by the trial attorney, and essentially it lets the trial attorney off the hook. The courts need experts. The Court of Appeals decision would make that more problematic. There's no insurance available for this type of liability, none that I'm aware of. Contrary to the appellee's argument, access to justice therefore will be impeded and not enhanced if experts can be sued. And finally, this court should consider the hall of mirrors that this new cause of action will create, because expert testimony will be needed to provide the standard of care for expert witness testimony, and those experts themselves would be exposed to litigation for providing that testimony. The Maiden decision is based upon a policy of supporting the duty to provide testimony that is truthful, untainted by underlying concerns of liability. That policy is undermined by the Court of Appeals decision in this case, so this court should grant leave to appeal and ultimately reverse the decision below. Thank you.
Thank you, counsel. We didn't think through how exactly when you're both on screen, I guess we can ask either of you to answer, but I think my question is for you, Ms. Klaus. Is there a difference between the immunity extending to the witness's testimony and some other alleged professional malpractice that may have happened in preparing for the testimony or in other services that the expert provided outside of the courtroom? And does it, aren't those kind of two separate questions, I guess, is what I'd like to hear from you about?
Your Honor, it can be if the expert is retained in a consulting role only. But when the expert is retained to give opinion testimony, I do believe that the immunity has to extend to all of the work that the expert did. And that was certainly the holding in Maiden, where it was very clear that the prosecutor testified in the malpractice case or the negligence case that he relied on the medical examiner's autopsy and other out-of-court, non-testimonial opinions in arresting and beginning the prosecution of the plaintiff in the first place. And if you think about it, Your Honor, it makes no sense that you could immunize an expert for an opinion given in court, but hold him liable for giving that opinion out of court. It abrogates the entire basis for the immunity.
I guess I didn't mean exactly on giving the opinion out of court. I meant just, assume we have the expert did all his preparation on Zoom and live streamed it to YouTube and was, drinking alcohol the whole time, was drunk, so he didn't read the right things. I mean, is there literally no professional malpractice that that is, compensable outside of testimony?
Not if the expert is going to be a witness. And I think, it's his status as a witness that immunizes him. Certainly there are cases in litigation where you hire consultants, and I'm thinking of e-discovery, for example. Yep. Those experts come in to help you, sift through and analyze that information, but they never testify. And there's no expectation that they would ever testify. That would be a different kind of malpractice. And certainly I think claims could exist against that type of expert, but that expert's not a witness. And to me, that's the function of the expert witness is what entitles them to immunity. It has to.
Okay, I understand. Let me turn to Justice Markman. Justice Markman, do you have any questions for the advocates?
No, thank you. I don't at this time.
Justice Zara?
No, thank you.
No questions. Justice Viviano? He's muted.
Yeah, sorry, I muted myself. I have no questions either. Thank you.
Justice Clement? Oh, I skipped over Justice Bernstein. Sorry, Justice Bernstein. Quiet down, Justice Clement. Justice Bernstein.
If I could hold and let Justice Clement ask her question, you come back to me.
Oh, sure. So I was reading your mind, Justice Clement.
Great, thank you. Mr. Brennan, you touched on Dowd. Could you just walk through the analysis under Dowd and Triplet and compare that to Maiden?
Well, the Dowd analysis, I was just referring essentially to the fact that the Dowd analysis is grounded its analysis on the concern about how expert witnesses would be free of the concern that they have about outcomes. Dowd focused on on the notion about the loser of the further litigation. I think the analysis in Dowd, I don't know if there's really, in a sense, any strict legal analysis or step-by-step analysis, except to say that the policy concern in Dowd versus Maiden are not different. I think Maiden adopted the Dowd's opinion with regard to its policy. So I don't sense that there's anything different about them. The concern really is in the need for the court process to be that there be integrity in the court process, and that integrity not be tainted by any concern that the witness would have about being potentially sued. And by the way, that exists not just for expert witnesses, but any witness. Supposing, for example, that a fact witness tells the attorney and the client a lie before they take the stand about what they're going to say, and when they take the stand under threat of perjury, they tell the truth. Well, are they liable for that? I mean, the point is that the extension of this, really, there's no reason why we should not. The policies apply whether we're dealing with experts or whether we're dealing with any witness. And the concern of Dowd and the concern of Maiden was in what is going in. The only fear that should be, and in any witness's mind when they testify, is, am I telling the truth? Otherwise, I could be subject for perjury.
Thank you.
Justice Bernstein, do you have any questions?
Yeah, I just have one question, and I just like to take things to their extreme because I think that kind of allows for a certain clarity. So let me just kind of pose a hypothetical. Could you have a situation, and again, this is going to your policy argument, where basically you could just, if you have a person who's consulting, and this is kind of an extension of Justice McCormick's question, but if you have someone basically that is serving in a consultative manner, the way Justice McCormick kind of had talked about, could you then see as a policy situation where you could just make this person an expert, have them appear on your list as an expert, and then allow for folks to serve kind of as a part of your legal team, as a part and be a part of your legal strategy, but make them an expert, have them qualified as an expert, put them on your list? Could you see a situation where this could then be taken to an extreme where basically you could have people that could in many situations be serving as kind of counsel or in that kind of capacity, being put as an expert in terms of a witness, maybe not calling them, but then immuning them, basically giving them immunity from any liability in terms of their conduct in this case or in a case such as this?
And I think the answer to that is certainly on the margins, there could be corruption of the sort that you're describing, Justice, where you try to immunize, everybody who's helping you. But the key is that in Michigan, the attorney would be liable for any negligence committed by people acting under his or her control, as Mr. Brennan said. The attorney would be liable for relying on bad testimony or faulty testimony, or I'm sorry, faulty consulting provided by the people he or she attempted to immunize. So there's a remedy there in that situation you described. There's a remedy for the injured party. The remedy just wouldn't lie against the expert. The remedy would lie against the attorney who falsely tried to immunize and then inappropriately relied on the incompetent opinions.
Thank you.
Thank you, counsel. Mr. Hilliard.
Hi, good morning, Justices. My name's Shane Hilliard. I'm an attorney with the Gallagher Law Firm here in East Lansing. We represent Kathleen Gaydos, the personal representative of the estate of the late Diana Voutsaras. It is my absolute privilege and honor to be appearing before all of you and to be opposing counsel with Mr. Brennan and Ms. Klaus. Maiden is the key case here, and it's clearly distinguishable from the facts in this Voutsaras versus Bender in 4 ways. First, Maiden, the underlying defendants in the Voutsaras case aren't county employees whose duties are imposed by statute, such as that in Maiden, where that witness who was being sued was the medical examiner and by statute had a duty to the state. Here, the underlying defendants, they're privately employed. They both have held themselves out to be experts. And they have no duty imposed by statute to the state. Secondly, in Maiden, those witnesses were serving in a quasi-judicial adjudicative capacity. That concept is often seen throughout Michigan's case law, such as giving immunity to friend of the court or immunity granted to a psychologist who performs court-ordered psychological testing. Here, these underlying defendants don't have this judicial or quasi-judicial capacity. Again, they're private attorneys and a private real estate broker who've held themselves out to be experts, retained by the Voutsaras. And here in Maiden, it's in there. Part of the analysis was, is this person without whom the judicial process couldn't function? Similar to the friend of the court, as an extension of the family court, although the court may function, it wouldn't function as effective without that additional arm. Here, the distinguishing fact is illustrated by the role the defendants play as experts, which differs from that of a medical examiner or a friend of the court, whose statutory roles and duties specifically align each other with the state. Here, as a retained expert, their duty is aligned specifically to the person whom retained them for their services. And in all the cases where the defendant was suing the person seeking an immunity, those parties were adversarial to each other. These defendants are, if quote unquote, friendly witnesses. The defendants hired their attorneys. Those attorneys vetted those experts. Based on the expert's opinion, the Voutsaras relied on that and chose to move forward with litigation. Those 4 points on Maiden really tip the scales in favor of affirming the Court of Appeals. Secondly, policy concerns. It's driven the application of witness immunity, in my opinion, well past the intended by the common law. The history of witness immunity comes from the common law, and it was applied specifically towards defamation cases. Here, the Supreme Court of Pennsylvania, they were unpersuaded that policy concerns are furthered by extending witness immunity to the witness immunity doctrine to professional negligence brought against an expert witness when the allegations of negligence weren't premised on substances of expert's opinion. And in the Supreme Court of Louisiana, interestingly enough, in 2002, they held that witness immunity, although did not extend to retained experts, they did say that they didn't believe that shielding a client's own professional witness from malpractice is necessary to ensure that frank and objective testimony is presented to the fact finder. The retained expert witness, rather than a court-appointed one, for example, contracts for money with a party, assisting preparing and presenting the client's case not only in the best light possible to him, but in a competent fashion. And so the retained expert function isn't contrary to what Ms. Klaus had in her opening, in her brief. That expert is an advocate, not only for the client, but to the court. And in the absence of immunity, the expert would be motivated by not simply by frankness and stuff, but by the fear of exposure to civil liability. These experts are, if you will, quote unquote, hired guns. And Ms. Klaus made a policy argument saying that without this witness immunity extending to experts, experts would then shade their opinion. And I'd like to note, however, contrary to that, in her brief on page 4, footnote number 2, her client specifically says in his engagement letter, listen, regardless of what my opinion is, it's going to be based on the facts. That tells me her own witness, or excuse me, her own expert, her own client says, witness immunity or not, I'm not shading it. I'm going to tell it like it is based on the information I've given. And I think that speaks volumes to that policy where perhaps the fear of expert shading. And it doesn't just go, I don't believe, to professionals such as lawyers, doctors, and such.
Mr. Hilliard, you're beyond your 5 minutes. So I'm going to interrupt you in case my colleagues have questions. And I want to ask you the first one. What do you make of the language in Maiden that says that witnesses are wholly immune from liability for the consequences of their testimony or related evaluations? What isn't the related evaluation language of Maiden doing some important work, and what work is that? What work is it doing?
Right. Well, I interpret that the important work, I believe, of an expert comes right in the beginning. If we hire an expert witness to come in and say, hey, this is our case, based on that expert witness's opinion, as the attorney, although I'm responsible for the, legal maneuvering, it's the client that ultimately has a decision whether or not we move forward. If the client, based on these pre-trial meetings and opinions that the expert gives, relied upon, we moved to trial, that same expert opinion relied upon by the client is going to be given in court. So I think the witness immunity can extend, or shouldn't extend, to retain the experts. It has to allow for both the pretrial opinion that's relied upon, as well as the testimony given. One would assume that the expert is not going to change his or her opinion from the beginning of the case to trial.
Okay, thank you. Justice Markman, do you have any questions?
No, I don't. Thank you, counsel.
Justice Zara?
No questions.
Justice Viviano?
I have no questions either. Thank you.
Justice Bernstein?
So counsel, I just want to understand, because I always like to take things, like I said, to sister counsel a little bit further to extremes. So at what point would you draw a distinction, and would you draw the line, basically stating whether or not an expert could be deemed to be civilly liable for their testimony?
I don't necessarily think there has to be a bright line rule. Obviously, if your honors uphold the Court of Appeals decision, this is going to be something new. Specifically in this case, however, we have two people holding themselves out to be experts. One's an attorney who requires the professional degree. The other one, licensed by the state. I believe both of them should be held to the same standard. Perhaps you provide a rebuttable presumption that if he who holds him or she holds themselves out to be an expert, the presumption is there's a duty there, and then you move forward. Did you breach the duty? So it's essentially a two-part trial. Was there a duty? If you're holding yourself out to be an expert, you have the opportunity to rebut that presumption.
So this would be, your perspective then would be that you would then use this as a case-by-case situation. So would that create ambiguity or unclarity when a person is asked to serve as an expert? I mean, is this going to create a situation where folks who, are true experts, this isn't like a full-time job that they do, but they're called to testify in a case? Is this now going to create a new burden or a new anxiety or a new apprehension in perspective to how you'd want to approach this, so that they would now have to worry about the fact that there could be a perspective that is now put into place based off of their testimony that they have to now consider?
No, I don't think it should be case by case. Maiden hasn't been case by case ever since its inception. Neither has the witness immunity doctrine. It's had a broad reach. And so similar, I think the retained experts and whatnot, there should be no narrowly focused case by case. If the vetting is done properly, or if the attorneys, such as the policy consideration Ms. Klaus made, that expert witnesses are gonna shade their testimony for fear, then they probably have consulted the wrong expert in the first place. I think this provides a more strict guideline. It provides all expert witnesses notices that the state of Michigan is not going to stand for, incompetence, negligence, or frivolous opinions just so that they can make a quick buck and not have some type of redress.
And counsel, I have one last question. How do you respond to sister counsel's argument that the sole responsibility or the ultimate responsibility lies with the trial attorney? Why is that not sufficient?
Well, essentially it does. However, the trial attorney is not telling the expert what his or her opinion is. So I could coach and provide all the information and our theory of the case. I'm not, however, giving the expert his or her opinion. His or her opinion is of his own. If that should be negligently given to where my client has relied on that, and we've carried through an entire case, and it proves that that opinion by that expert, whether it's a professional degree carrying expert or just a state license expert, there has to be some sort of redress for that. And that doesn't fall on the attorney, I don't believe, because the attorney isn't providing the expert witness's opinion. He or she is doing that himself or herself.
Thank you.
Justice Clement.
No questions. Thank you.
Well, thank you very much, counsel, for being willing to participate in this format. I should have said at the start of the case, Justice Kavanaugh is not participating in this case. That's the only reason she doesn't appear on your screen. Mr. Brennan, Ms. Klaus, I am sorry, but we used up your time and then some. That's what Justice Bernstein does. Just get used to it.
Even on Zoom.
Even on Zoom, he finds a way to use up your time. But we appreciate your arguments. I think it's incredibly helpful to us as we work through the questions in this case. The case will be submitted. The live stream will continue at 10:30 with the next case, but we're going to go offline now. Thank you all very much.
Thank
Thank
you
you,
very
Your Honors.
much.